George closing on the sale of his home here in Louisville on the 19th of this month. His agent just received an unusual request from the buyer's agent asking that George and his wife sign the disclosure on the condition of the house after they close, indicating nothing has changed since the disclosure was filled out when the home originally was listed. So the buyers are apparently from Southern Indiana, from what this email says. And if I'm not mistaken, Corey, you and I both know, as I'm licensed in Southern Indiana, that that's a process that occurs in Southern Indiana and Indiana, but not in Louisville, right?
Correct.
Yeah. So this kind of an unusual request for a Louisville buyer? Yeah.
It is unusual. However, duty would dictate that in the event there were any changes, that they reissue that seller's disclosure during the course of that transaction with those updates, that they provide notice of same in lieu of, or I guess in the updated seller's disclosure to the buyer.
Yeah.
So it's not simply, hey, at the time of listing or the time we showed the property, here's your seller's disclosure, and you have your inspection, and up until closing, I don't have to disclose anything further. If anything were to happen, you have to revise that and provide it. So if nothing happened, you having to sign it and just saying that nothing happened, and they're just updating their paperwork as a course of that, I suppose it wouldn't hurt anything. However, is it necessary? Is it legally required? No, it's not. So, I don't know that I would sign anything that's not required unless you just really didn't want to upset the apple cart and they were kind of pushing back. I don't know necessarily the harm, so long as there wasn't anything. But again, being that it's not legally required, I probably wouldn't sign anything here in Kentucky if I knew nothing had changed. Your duty's there. If you didn't have to update it, that should be good enough.
Shouldn't, or do you think that not signing it could indicate to the buyer that maybe something is wrong? I mean, are we setting ourselves up for a potential failure for George if he doesn't sign it? You think it's going to go forward anyway, huh?
In my opinion, I don't believe so.
Okay.
So if they're threatening not closing as a result of, in exchange of these signatures, again, it not being legally required, I don't see how there could be any legs to that argument. Moreover, that representation that's made in that seller's disclosure, that's going to survive closing. So in the event there were a misrepresentation claim, that is still a viable claim that the buyer can move forward with post-closing if there was, something that they knew or should have known about on that seller's disclosure and it wasn't disclosed. So them declining to sign something saying it hasn't changed doesn't change the buyer's position that they may or may not still have an argument post-closing if something was not properly disclosed. Does that make sense?
It does. And maybe the agent for the buyer needs to explain that to the buyer.
Absolutely. Or certainly they can ask their closing attorney. That's what we're here for at the closing table, is to answer questions, last minute issues that come up, in addition to going over all of the closing paperwork, the loan paperwork, etc.